Just want to quickly thank and congratulate Morgan Larson again for an incredible symposium and the entire ASU FedSoc chapter. Good afternoon. My name is Diego Morris, and I'm a 2L student here at Sandra Day O'Connor College of Law. For a brief moment, I would like us all to take a trip down memory lane. Try to recall what your favorite sport or hobby or activity was when you were 11 years old. Could have been football, basketball, video games, theater, the list goes on. For me, it was baseball. And not to brag, but I was pretty good at it. Unfortunately, during my winter season at age 11, I began feeling a strong pain in my left knee. After seeing multiple specialists, a local orthopedic surgeon examined an x-ray and promptly asked if I could wait in the lobby for a few minutes so he could chat with my mom. With my mom in tears, the surgeon informed her that he believed I had a bone tumor. After an immediate biopsy, I started my first round of chemotherapy only a few weeks later. I was diagnosed with osteosarcoma, a rare bone tumor that typically impacts adolescents in large times of growth. I ultimately underwent limb salvage surgery to replace my partial femur, knee, and partial tibia with a titanium prosthesis. After receiving the necrosis of the tumor, or the percentage of the tumor killed by the initial chemotherapy, my physicians were less than thrilled. My family immediately started looking at any possible experimental treatments that could improve my condition. We began consulting with experts around the world, and it quickly became clear that an immunotherapy treatment called mefirmatide, or MTP, was demonstrating excellent results in ensuring my specific cancer never came back. Sadly, despite all trials having been conducted in the United States, FDA bureaucracy and overregulation led to the FDA never approving the treatment for use despite its promise. My time was short. I needed access to this treatment to coincide with my chemotherapy in order for it to be most effective. Even attempting to go through the FDA, all of their expanded access programs would have taken far too long to gain approval. My family made the difficult decision to uproot our lives and move to London so I could receive this treatment along with my chemo. I remain forever grateful to my family for making this sacrifice. Upon returning to Arizona, cancer-free, my family was approached by the Goldwater Institute, the organization pushing for nationwide reform via right-to-try legislation. Their team explained the legislation, the terminally ill patients they were seeking to help, and the ways in which I could get involved in the campaign. From the age of 13 to 18, I traveled the country to speak with legislators about my story and why right-to-try legislation could potentially save lives and provide access to investigational treatments. I gave interviews to local and national media outlets and testified before the United States Senate Committee on Homeland Security and Governmental Affairs. Finally, in 2018, I was invited to the White House by President Trump to attend the signing ceremony of the federal version of the legislation. The original right-to-try laws, enacted in 41 states and federally in 2018, provide a pathway for terminally ill patients to access investigational drugs, biologics, and devices that have completed a phase 1 clinical trial. These laws aim to provide hope and a potential last resort for patients facing terminal illnesses. Building on the success of the original law, the Goldwater Institute is now advancing Right-to-Try 2.0 for individualized treatments, specifically focused on investigational treatments that are highly personalized and on the cutting edge of therapy for patients with rare and ultra-rare diseases. This panel, Mandates, Medicine, and Liberty, examines a question that lies at the heart of constitutional governance. How should the law balance government authority to protect public health with an individual's right to make personal medical decisions? Throughout our nation's history, courts have wrestled with this tension between public welfare and the principle that Americans possess a fundamental interest in bodily autonomy. As new medical technologies and public health policies evolve, so too does this legal debate. I'm honored to introduce this panel's moderator, the Honorable Jennifer Perkins. Judge Perkins began service on the Arizona Court of Appeals, Division I on October 30th, 2017. At the time of her appointment by Governor Doug Ducey, Judge Perkins was Assistant Solicitor General for the state of Arizona. Judge Perkins was born in Portales, New Mexico, and primarily was raised in Albuquerque before moving to Washington, D.C. to attend the George Washington University as a National Merit Scholar. Thereafter, she relocated again to Dallas, Texas, and earned her Juris Doctor from the SMU Dedman School of Law, graduating cum laude in 2002. Judge Perkins started her career at the law firm of Browning and Pfeiffer, now Pfeiffer, Hansen, Mullins, and Baker, in Albuquerque, New Mexico. In 2003, the judge accompanied the Honorable James O. Browning in transitioning to the Federal District Court bench, serving as his first law clerk. After her clerkship, Judge Perkins moved to Arizona to work for the Institute for Justice. She spent 5 years with IJAZ litigating civil rights cases in Arizona and across the country. In 2009, the judge became disciplinary counsel for the Arizona Commission on Judicial Conduct, where she reviewed and prosecuted ethics complaints against state court judges throughout Arizona. After 5 years serving the state in this capacity, Judge Perkins entered private practice by joining an appellate law firm in Phoenix. In January 2015, Judge Perkins joined the Office of the Arizona Attorney General to serve as the first Assistant Solicitor General. In that capacity, she was responsible for oversight of Attorney General opinions and served as ethics counsel to the entire office. In addition to these two primary roles, the judge assisted on a variety of matters, including trial and appellate litigation of election-related matters, federal appellate litigation with the Federalism Unit, state criminal appeals, and drafting amicus briefs on behalf of Arizona in state and federal courts. Thank you for joining us, Judge Perkins.
Thank you to the stalwart for still joining us. Few questions in constitutional law are more enduring or more contested than this one. Who decides what happens to the human body? A generation of litigation, legislation, cultural conflict has made explicit what was once implicit, forcing courts, legislatures, and scholars to grapple with how to define with legal precision what it means to be free in one's own person. This panel is going to examine that question from distinct vantage points. The right, as you have just heard, of a dying patient to try an unapproved treatment. The authority of a state to restrict medical procedures for minors whose parents and physicians would otherwise consent. The power of a legislature to limit or prohibit abortion. Each of these controversies invokes bodily autonomy. Arguably, each reaches a different conclusion. Together, I think they reveal that the right to choose is not a single legal concept, but a contested battleground where competing interests, individual liberty, parental authority, state police power, and the protection of vulnerable persons collide. Our panelists will approach these questions from their different but overlapping perspectives: the litigation trenches of healthcare freedom advocacy, the front lines of state-level constitutional defense, and the philosophical foundations on which any durable legal framework must ultimately rest. So I'm going to introduce our speakers in the order that they will speak. Each will have an opportunity to give some opening remarks. We hope to engage in a little bit of panel conversation, but we also hope to hear from you with questions toward the end. And in honor of our stalwart last panel audience, therefore one lucky audience member who sticks it out and comes forward with a question at the end, I have a prize for you. So I hope you stick around for the whole time. Professor Hadley Arkes has been a member of the Amherst College faculty since 1966, and since 1987, he has been the Edward Ney Professor of Jurisprudence. In 2016, he assumed emeritus status. He is the author of numerous books and articles, predominantly focused on natural rights. His articles have appeared in professional journals, but he has become known to a wider audience through his writings in the Wall Street Journal, the Weekly Standard, and National Review. He has been a contributor also to First Things, a journal that took its name from his book of that title. And as the convener of the Phoenix Rafters chapter, I particularly appreciate that contribution. Dr. Arkes was the main advocate and architect of the bill that became later known as the Born Alive Infants Protection Act. This act ultimately passed, and President Bush signed it into law in August of 2002. Professor Arkes has been the founder at Amherst College of the Committee for the American Founding, a group of alumni and students seeking to preserve the doctrines of natural rights taught by the American founders and Lincoln. That interest has been carried over now to the founding of the new Center for Jurisprudence of Natural Law in D.C., the James Wilson Institute on Natural Rights and the American Founding. After Professor Arkes, we will hear from Christina Sandefur, who is the Executive Vice President at the Goldwater Institute. She develops policies and litigates cases advancing healthcare freedom, free enterprise, private property rights, free speech, and taxpayer rights. There's a lot of liberty in there. We're going to focus a little bit today, but Christina is a co-drafter of the Right to Try initiative that you heard about a few moments ago, which is now federal law, and which she will tell us more about when she has the opportunity shortly. She has also won important victories for property rights in Arizona and works nationally to promote the Institute's Private Property Rights Protection Act, which is a state-level reform requiring governments to pay owners when regulations destroy property rights and reduce property values. She is the co-author of the book Cornerstone of Liberty, Private Property Rights in 21st Century America. And she is a frequent guest on national television and radio programs. She's provided expert legal testimony to various legislative committees and is a frequent speaker at conferences. She is the recipient of the 2018 Buckley Award in recognition of her leadership in the freedom movement, and she is an advisory board member of the Network of Enlightened Women, which I haven't heard about, but perhaps we should talk on that. Christina serves on the board of the Phoenix Lawyers chapter of the Federalist Society, which I hope all of you are grateful for here, and is a member of the Executive Committee for the Federalist Society's Regulatory Transparency Project, FDA, and Health. She's a graduate of Michigan State University College of Law and Hillsdale College. And batting cleanup for this panel is Stephen J. Griffin, the Deputy Attorney General and Director of the Civil Rights Enforcement Division at the Tennessee Attorney General's Office, which is a role he assumed just this past July 2025 after serving nearly 3 years as Senior Counsel for Strategic Litigation in that same office. His tenure in public service has included high-profile constitutional litigation, most notably serving on the team representing Tennessee in United States versus Scrimeti, and he is currently participating in the litigation challenging Tennessee's abortion laws. Before joining the Tennessee's AG's office, Griffin spent over 12 years as a shareholder at Daniel Coker Horton & Bell in Jackson, Mississippi, where he built a broad civil litigation defense practice with a particular focus on Section 1983 civil rights claims and tort litigation on behalf of government entities, corporations, and individuals. His practice spanned personal injury, products liability, professional liability, and appellate work. Griffin earned his J.D. magna cum laude from the University of Mississippi School of Law, where he served on the Law Journal and Dean's Leadership Council. He also holds a B.A. magna cum laude in political science and journalism from Ole Miss, where he was inducted into Phi Beta Kappa. And with that, Professor Arkes, the floor is yours.
Stumbling. Is this on? Can you hear me? Listen, thanks so much, Judge. I'm honored to be on this panel with you presiding, especially with Steve Griffin and Christina. Steve is coming from one of the most formidable offices of the Attorney General. We've been working with Jonathan Scrimeti. It's a terrific group. And Christina has done a terrific paper. I'm so pleased to be joining with him today. I wonder, why am I on this panel? I can't resist a drawback to Elon. He's not here anymore, is he? But he. Oh, there you are. No, great to see you, Elon. I want to draw back when he was doing Lincoln's response to Stephen Douglas, his understanding of Dred Scott, this came up during the hearings on our Born Alive Infants Protection Act to protect the child who survived the abortion. And I was recalling Lincoln's argument that we would, if the court decides Dred Scott to be a slave, we will not form a mob to free him. We'll respect the outcome of the case in regard to those litigants. But if we're not persuaded by the principle on which they drew their distinction. We're not obliged to apply to that principle to anything else that comes under our hand. Well, my nemesis, Jerry Nadler, picked up on that. And he said, hey, Professor, maybe we ought to try our hand at countering some other cases, like revising other cases, like Bush versus Gore. I said, Congressman, you really should try just get practice at it. But remember, you just have to respect the outcome of the case in regard to those two litigants. Right? Okay. The philosopher Wittgenstein imagined a case in which parents, leaving a child with a babysitter, say, while we're gone, teach that child a game. And while they're away, she teaches the children how to shoot craps. Rolling dice for life. Well, that's not what they meant. Well, how should she know? I remember years ago, before leaving the kids with a babysitter, I'd said, look, if there's a fire in the house, my manuscript for the new book is right over the shelf. Get that out of the house. And you get Peter and Jeremy out also. You get the kids out also. I once reimagined the babysitter case with the babysitter, the daughter of parents engaged in the Hemlock Society, strongly supporting the right to die or the right to have help in suicide. And the daughter now is a babysitter for 2 children. A fire rages. She's been taught that death is a good to be chosen. Should she alert the children that they have a choice? Well, no one would take such a story, take such a thing seriously. In the most deeply planted natural understanding, we understand that death simply cannot stand as a rival good to life. John Finnis used to point out that deep premise that life is a good is engaged every time people look both ways before crossing a busy street. Or we have drives to raise food for people suffering famine, not drives to withhold food, let people we don't need starve to death. It's simply not thinkable that we could constitute any medical emergency unit or any ambulance unit working on the principle that the object is to get people who've been injured, then quickly dispatch them to help them end their lives without pain, to relieve their relatives of the need to make some tough end-of-life decisions, and whether to keep Uncle Julius alive. In that vein, our beloved Justice Scalia once, in the Cruz case on the right to die in 1989, I said, I want to offer a word of advice to people running ambulance services. You will not be faced with an action under 1983 to violating someone's civil rights by denying him a constitutional right. What right? The right to die. He said, this claim to right does not rise to that level. Now, it may be that I have the means of reaching across and striking Christina. That I have a means to do it does not mean that I have a right to do it. Some other words would have to be said to establish the rightness of doing it. Precisely in the same way, I may have the means of killing myself. That's not to establish that there's something rightful in killing myself. At the same time, compel doctors and nurses to act as accomplices and agents in helping me with that kind of a killing. People laden with guilt come into precincts of New York every other week confessing to crimes they didn't commit. Their passion to punish themselves is not taken by the authorities as a warrant for punishing them, let alone a right on their side to punish themselves for wrong they did not commit. There's the old case, of course, of the conscientious Nazi who is persuaded that all Jews should be sent to death camps. When he discovers that he had a Jewish grandmother, he's perfectly willing to honor the precept and go to the wall himself. And of course, his willingness to respect that principle as applied to himself does not itself establish the rightness of his doing it or killing any other person who is Jewish. The vicious Heinrich Himmler, took a poison pill rather than suffer the experience of being taken prisoner at the end of the war. We might say that Himmler deserved to die for what he had done, but not at his own hand, for that would have been a matter of killing people on the surge of his own will, much as he ordered up the death of others. He deserved to die, but he deserved to die after a trial gauging the depth of his evil. And as Hannah Arendt said of Eichmann, with the judgment saying, the rest of us just don't deserve to share the earth with you. We used to have a term more widely understood at an earlier time about things so wrong we may not do them to ourselves. And so we used to speak of unalienable rights, rights we may not waive or alienate even for ourselves. So in this vein, the court held, you may recall, in Bodily versus Alabama, 1911. Now, we don't have a right to contract yourself into peonage, even if you get 3 square meals a day. We long ago banned dueling for consenting adults. And when we do bar suicide in the law, we remind ourselves that there is a moral law around us that may stand against our willingness, our willfulness, and things we're willing to order up even for ourselves. And of course, all of this would supply the main lines of argument that may be engaged by the public authorities when they seek to impose, through the laws, a scheme of vaccination or policies to preserve the lives of people, even when people find the terms disagreeable. And so we impose requirements of seatbelts in cars, helmets for people who are on motorcycles or bicycling. At times, people are ordered to be pierced with injections they do not want. The justification for such a policy becomes more compelling and plausible when there's a firm ground for concluding that the vaccine will protect life and the health of anyone who receives it, and that way protect a wide array of people who could be affected. In my own lifetime, of course, the most dramatic illustration on that head came with the Salk vaccine, which relieved so many of us teenagers of the fear that we could be stricken with the same infantile paralysis that had stricken Franklin Delano Roosevelt. But with COVID, we had a different experience. There were people who had run-ins with the disease. They thought they had immunity. There's a question of whether COVID could be treated with other drugs. And there was the judgment of my dear cousin Hal Arkes, a distinguished psychologist who devoted his whole career to the study of medical judgment and misjudgment. He declined to take the vaccine in his own judgment. That vaccine, brought forth in suspiciously record time under Operation Warp Speed, did not have the real properties of a vaccine. Back in 1970, President Ford called a halt to the swine flu vaccine when 24 deaths occurred. And they were thought connected to the vaccine. But with COVID, there were more deaths. And in one extended study with 9 million patients worldwide, there was withdrawal from the ChAdOx1 vaccine, something developed at Oxford, when there are some statistically significant correlations with the onset of cerebral venous sinus thrombosis, a rare form of stroke caused by blood clots in the veins of the brain. And on this matter, I must tell you, I had some jolting experience myself. A person very dear to me, may I say very dear to me, died in her sleep of cardiac arrest at the age of 49. And the best guess of the doctors, whose judgment I trust, is that she died as a reaction to the vaccine, which she had only 2 weeks prior to her death. The medical examiners could find no other plausible cause of death for someone of that age, suffering cardiac arrest, and perhaps joining a long list of people whose unaccountable deaths have pointed to the vaccine as a possible explanation. If she'd been married to my cousin Hal, she would probably still be alive. But the issue that really sharpens the moral and legal question you have laid, and that seriously tests the seams of the arguments among my friends doing conservative jurisprudence, is the issues of orphan's disease, the rare conditions that find it hard to attract money to develop medications. Some of them approach the threshold of plausibility, showing some serious promise, and yet not enough to persuade people of the FDA to drop their refusal of permission to try the drug, even when the patients are desperate to try it and to take their chances with the risk of their own lives. The issue has been taken up recently by my pals at the Wall Street Journal, who've been on a tear recently about this late chief of biological divisions of the Federal Drug Administration, Vinay Prasad, in his deep aversion to giving even a tentative pass on certain drugs in development. They have not been through a thorough testing at the FDA. And so the FDA just recently rejected Regenexx Bio's gene therapy for Hunter syndrome, which involves kind of a toxic buildup of sugars, which can be especially damaging to the brain. Adolescents may end up in a vegetative state and die. The FDA had given signs of approval before the clinical trials, but with the advent of Dr. Prasad, the approval was withdrawn. He wanted a more demanding trial with a placebo, but that could be rather tricky in a rare disease, and there was an ethical problem in giving some children a placebo in testing for a fatal disease. So in the meantime, some young people will be in danger, but the late news is that Dr. Prasad was pushed out of the FDA again, though we still don't know what that means for the approval of drugs dealing with, say, Hunter syndrome. But the case that really tests the seams of the argument and really tees up the problem for Christina is the Abigail Alliance case, that fine opinion written by my friend Doug Ginsburg almost 20 years ago for the DC Circuit. The Abigail Alliance represented patients who were terminally ill, sought expanded access to experimental drugs that had gone through at least the phase one of established clinical trials. But the concern here is that the testing process, quite demanding, could require as much as 7 years of trials. The claim proffered by the Alliance was that it was a claim of the right for patients in mortal peril to get access to drugs that have not been fully tested yet for their efficacy. Christine will draw upon that later, to test for safety then efficacy. Tested for efficacy if the patients were willing to bear the risk of themselves for protecting their own lives. The claim was rejected in the federal district courts, but it was sustained in a divided panel of the DC Circuit, written by my friend Doug Ginsburg. He was appealing, of course, to that deepest natural right of a person to preserve his own life against unjustified assaults or hazardous conditions. The right to life never meant that it meant a right to life everlasting, or that the government could not put you in harm's way in defense of the country, or even take your life in capital punishment. But aside from those situations, there's a deep right on the part of people to have access to lethal weapons in self-defense, to ward off other unjustified threats to their lives. And of course, there was an authority on the part of the government to protect persons, citizens and non-citizens, from unjustified assaults on their lives, as with the authorities ordering the searching of bags in New York City when there's a threat of bombs. Christian people who talk about constitutional right, they'd invoke rights against searches and seizures. What they were neglecting was natural rights as understood by the founders, that it was the authorities in New York that were acting to protect the lives of ordinary people, to have their lives taken in an unjustified way with a bombing. Judge Ginsburg's decision was meant to remove the barriers to the approval of new drugs, but it was overturned in an en banc appeal in a panel containing, I say, good friends of mine and considerable judges, such as Janice Rogers Brown, Ray Randolph, and young Brett Kavanaugh. And yet the kind of opinion brought forth by another friend, Tom Griffin, was the kind that should really kind of embarrass us all. For in Judge Griffith's hand, the nature of the right was recast and transformed here. It was converted into a right contained in a state of regulation. The right of getting access to drugs that have not yet been proven to be effective and safe according to the procedures set up by the Food and Drug Administration. Now, in order to invert things in this way, Judge Griffin had to invoke the boogeyman for conservatives of substantive due process. In other words, rights that have been drawn out at different times through the Due Process Clause on matters that were never made explicit in the text of the Constitution, and never made explicit in part because the framers could not put in the Constitution everything they happened to know, or because those rights were so taken for granted there didn't seem to be any need to make them explicit, as, for example, parental rights, the right of parents to arrange for the education and medical treatment of their own children. And yet these key rights drawn out in different cases, using the due process clause, have been sneered at as matters of substantive due process, rights to be regarded with a lesser reverence because they were not set down in the text of the Constitution. My dear late friend Anthony Scalia was one of those people sneering at substantive due process in this way. And when conservatives saw people invoking these new rights, they were kind of a fork in the road. They could take the path noted by Justice Cardozo years ago, and where we'd say, well, the right could be drawn as we draw out the implications of the very logic of the rule of law or constitutional order. No penalty without a verdict, no verdict without a serious trial. Or as my friend Dick Helmholtz at the University of Chicago would say, a summons. It's not in the Constitution. Someone targeted for prosecution has a right to be alerted that he is a target for prosecution. Okay? That is one path. But conservatives were just drawing out the implications that arise from the constitutional order. But conservatives, that's not the path favored by conservatives, because it means uncovering or discovering the substantive moral truths that are simply embedded in the logic of law or a constitutional order. Conservatives prefer a path that involves no moral judgment. They look rather to find out whether there's a long tradition of our law that we've ever recognized, say, a right to abortion. I raise the question, what the conservatives would do now about that decision in Buck versus Bell. Have we found a long right in our history not to be subjected to compulsory sterilization? How would we do that if not through the due process clause? But now, Judge Griffin would ask whether that long record in the law revealed a right to have access to life-saving drugs if they have not been tested for the effectiveness and safety by an agency of the federal government. In other words, the notion of natural rights was now eclipsed. It was my right to protect my life only with drugs that have been cleared by the regulatory state, which has accorded them the real sovereign authority over our lives. The bizarre thing here is that conservative judges, so wary of appealing to moral truths outside the text of the Constitution, think they have to search for a light to life through the due process clause by looking at the record and history of our laws. And what is strangely eclipsed in all of this is that our very regime, before the Constitution, begins with the Declaration of Independence, with certain unalienable rights that are there before the Constitution, such as our natural rights not to have our lives taken, our freedom restricted, our property taken without justification. As James Wilson said, it's never out of season to quote him, we didn't bring forth this new government for the sake of inventing new rights, but rather to secure and enlarge those rights we already had. By nature, it was the protection of those natural rights that formed the very rationale or justification for this government, or why we were forming this new government in the first place, and the securing of those rights marked the real telos, or purpose, of every branch of the government, the executive and the legislative, not merely of the judiciary. What we found in the Abigail Lyons case was that it revealed a conservative jurisprudence quite detached from the first principles or anchoring truths of the Constitution, even on the part of people who styled themselves originalists, people who want to respect the original meaning of the Constitution as it was understood by those gifted men who shaped it and understood also its anchoring moral grounds. So we've seen in our own time, I submit to you, is that a conservative jurisprudence detached from those anchoring moral grounds may deliver us at times things we regard as wins. But what they've shown us is that they cannot give us a conservative jurisprudence that can give a morally coherent account of itself and the law we're trying to shape. And that, I suggest to you, is the moral crisis that's with us right now within the conservative camp. Thank you.
All right, well, I want to get back to talking a little bit about the Right to Try movement, and I will say, Diego, it was such an honor to share the stage with you here today. The work that I'm going to be talking about is in large part made possible because of your bravery and your courage and all the hard work that you put in over the years. So thank you so much for being here. The Right to Try movement was really a response to the real-world consequence of restricting medical autonomy, types of things that Dr. Arkes was talking about, especially for terminally ill patients who have exhausted all government-approved options. Now, the default in the United States, and this is a whole different panel and a whole different discussion, so I won't get into a deep dive here, but the default in the United States has long been regulation over innovation, and that has resulted in this slow, often inaccessible process for accessing healthcare. Today, treatments have to undergo decades of mandatory clinical trial testing to determine to the government's satisfaction that they're not only safe, but as Dr. Arkes said, effective. So we know that the treatment's not going to kill you. Now we're going to test for a number of years, again, to the government's satisfaction that that treatment is going to be effective. And remember that, we're going to talk about that a little bit later. The result of this, especially for dying patients, make no mistake, is that most patients are out of luck waiting for treatments that could potentially save their lives. Those not lucky enough to get into a clinical trial, and only about 3% of the sickest patients are fortunate enough to get into clinical trials. And clinical trials, by the way, are very good ways to study drugs that are going to apply to large populations. But they're answering a very specific scientific question, right? So the population that's going to be admitted to that clinical trial is going to be very specific. And that's why only about 3% of the sickest patients make it into a clinical trial. So outside of those 3%, or the few that are able to be granted a special government exemption through long periods of paperwork and begging for their rights, the rest of them are out of luck. So before we talk more about Right to Try, let's go back to the concept of medical autonomy. So if we go back to first principles, a person owns her own life. And if a person owns her own life, then the right to medical autonomy, the right to make one's own medical choices, in my mind, must be fundamental. After all, it underpins the ability to exercise all other rights. And a system, then, that prioritizes the preferences of policymakers, whether it be Congress or the Federal Food and Drug Administration or what have you, at the expense of a person's right to shape her own destiny is fundamentally at odds with this principle. Now, there have been a long line of cases, both at the Supreme Court level and all the way down to the district court level, that have acknowledged the importance of medical autonomy, and these cases go back decades and decades and decades. They've upheld the ability, for example, to refuse life-saving treatment, the ability to be free of unwanted bodily intrusions. And then there are some really fun district court cases like those that have upheld the ability of one to decide whether or not to choose to cut his own hair. Case about a 17-year-old high school student, for example. But these are all medical autonomy cases. These are all cases that recognize the importance of medical autonomy. Medical paternalism treats individuals, frankly, as children, people who should be protected from making the wrong decisions, because that's really what we're saying, right, when the government steps in and makes these critical decisions for you, that you could make the wrong decision and therefore suffer some harm. But free people have to be free to make even what we might consider bad decisions, right? Because it is only that individual who makes that decision that is going to suffer the primary consequences or enjoy the rewards of that decision. Otherwise, if you can't be free to make the wrong decision or a bad decision, then you aren't truly free. Now, people will say, well, what about following the science? Well, what does that mean? Questions about how we choose to live our lives, they really aren't scientific or medical questions. And don't get me wrong, Science and medicine are important, and science and medicine can answer critical questions. But science answers questions about reality. It doesn't answer questions about how people should deal with that reality and what consequences they're willing to face as a result of making those decisions. Scientific experts are experts on science. They are not experts on individual people's values. And if scientists are not experts on individual people's values, then certainly our elected officials or our unelected bureaucrats are not experts on your individual values. Whether a drug then is acceptably risky isn't a scientific judgment. It's a normative judgment, and it's going to vary from person to person depending on that person's individual risk-benefit tolerance. Also, no system has perfect information, right? Unsafe drugs. We say, oh, we wouldn't want to take unsafe drugs. The FDA shouldn't, exist because it's going to keep unsafe drugs off the market. Well, almost a third of all FDA-approved drugs are later flagged or even sometimes removed for safety concerns. And in the meantime, drugs languish, again, for decades, literally for decades, being tested to prove efficacy, that they are effective, not just safe, but effective. Yet, even after approval, we know that individual patients, they can respond very differently to the same treatment. So one treatment isn't going to be effective in the same way for every single person out there. So by definition, we are drawing sort of arbitrary guidelines for when something is acceptably effective enough to allow people to choose to take it. So some would say, well, this uncertainty justifies paternalism. But no, I would argue uncertainty doesn't justify paternalism, quite the opposite, especially when there are unknowns. We have to defer to the risk tolerance of the individual. Because the question of whether a risk is an acceptable risk, it's not scientific and it's not medical, right? The life is the patient's. The right to live as well as we see fit, well, that's what makes life more than mere existence. That's what allows us to not just survive, but to thrive, and it is critical. Okay, so now let's get to right to try. So one of the most compelling cases for medical autonomy is what you've heard both Diego and Dr. Arkes talk about, the right to try, the fact that dying people who are out of government-approved options, who want to try an investigational medicine that their doctor thinks might help them, in fact, it might be the only shot out there to help them and to improve and to save their lives, but it could be years or even decades away from getting final approval. Now, as Dr. Arkes alluded, the right to try was actually tested in court nearly 20 years ago in the Abigail Alliance case. Briefly, what was this case about? Well, there's a young woman named Abigail Burroughs. She was 19 years old when she was diagnosed with head and neck cancer, and she was out of government-approved options. There was a clinical trial that was being held to test a treatment that her doctor thought might save her life, and she wanted very badly to get into that clinical trial, but unfortunately, that trial was testing that drug to see how it would treat colon cancer. Now, if you know anything about cancer treatments, you know oftentimes they are prescribed off-label, so it might be approved for colon cancer, but be perfectly effective to treat head and neck cancer. But of course, this is a clinical trial, this is a scientific experiment, and we need to keep the group narrow. So Abigail was not allowed to get into the trial, and she was not allowed to get access to the medication. In fact, she passed away only a few years later, never having been able to try a medicine that could potentially save her life. And her father took up her cause. He took the case, he created the Abigail Alliance for better access to developmental drugs, took the case to court, and as Dr. Arkes outlined, argued that terminally ill patients should have the right to try treatments that have not yet received government approval, but are basically were deemed safe enough to test on human subjects in clinical trials. And all we're doing now is testing to see dosage and effectiveness, and people who are sick and dying should have the same options as those who were admitted into the clinical trials. And as Dr. Arkes said a 3-judge panel initially said that, yes, the Due Process Clause does guarantee terminally ill patients that right to try safe, right, according to the government, investigational treatments, and that was reversed by the en banc panel. Now, the en banc panel, and this is very important for those of you who are in law school, said that you don't have a fundamental right. What you have is a liberty interest. And if you have a liberty interest, then, as we noted, the rational basis test applies. You have no right to assume that risk. Now, what's the difference between a fundamental right and a liberty interest? Sounds to your average listener to be the same thing, but those of you who are lawyers or in law school know that it makes all the difference in the world, because the burden shifts to the individual to prove that they should be free to be able to do the thing. And the court said legislators, they have the power under such circumstances to balance the rights and benefits. The same rights and risks and benefits, by the way, that I said, if medical autonomy was a fundamental right that you should be able to decide for yourself, well, here we're going to defer to legislators. They're entitled to deference. They get to make that decision for you. And unfortunately, the Supreme Court didn't take the case, so we've never had a Supreme Court ruling directly on point here about what I would argue is one of the most critical rights of all. So dying patients were left in the lurch. No luck with the FDA, no luck with Congress, and no luck with the courts. And that's why my colleagues at the Goldwater Institute and Diego and patients across the country got involved with the right to try and started in the one remaining option, the states. Now, very briefly, because those of you who have studied the Supremacy Clause are probably wondering, well, if the FDA prohibits patients from trying these treatments, then how can the state do this? Well, states have broad powers to protect rights when the federal government fails to do so, right? We have our federal constitution, which creates a floor for protecting rights, and then all of the states have constitutions as well, and states have also been given recognized by the courts wide latitude to regulate the practice of medicine. Now, we mentioned physician-assisted suicide laws. In fact, the Supreme Court, right around the time of the Abigail Alliance decision, recognized that states, like the state of Oregon, have the power to enact right-to-die laws or physician-assisted suicide laws, even against the objection of the federal government. So our theory was, if states have the power to protect the right to die, they certainly should have the power to protect the right to try to save your own life. And in just a few short years, which if you know anything about legislation is just a remarkable feat, 41 states passed right-to-try laws, and treatments were taking place across the country. People were being treated and lives were being saved under state laws. Congress could no longer ignore the issue, and they passed the federal law in 2018. But as I said at the beginning, innovation outpaces regulation, and treatments of the future, they're just not one size fits all. So individualized treatments, treatments that are designed for one particular person using their unique genetic information, these are the treatments of the future. But this is sort of a square peg in a round hole, right? If you think about clinical trials, they're designed for treatments that work on large groups of people. They're designed for large populations. And by definition, a treatment designed for one person cannot go through a clinical trial. So it not only is not subject to right to try, but it really can't get FDA approval whatsoever. Hence, right to try 2.0. So far, 16 states, and actually I just got news today that we are almost on the verge of 17 states. The legislature of West Virginia just passed right to try 2.0. As being passed, it applies the principles of right to try to individualized treatment, and Congress is already taking note and drafting legislation. Now, I'll end here by saying that right to try and right to try 2.0 are incredible success stories, truly are. But why, if you think about it, it is the failure of the courts that have left patients essentially playing whack-a-mole, passing state laws, passing federal laws. Now as innovation changes the nature of treatments, have to go back and pass more laws again. Nobody should have to beg their legislators for the right to try to save their own lives. This is, I would argue, a fundamental right that the court should have protected and that the courts failed to protect. True respect for liberty means empowering individuals to make their own medical decisions, even when, and I would argue especially when, those choices involve great risk. So thank you very much.
Everyone, thank you guys for sticking around to the last panel of the day. I'm here to offer a little bit different perspective than what Christina just presented, which is being at the Tennessee Attorney General's office, I get to help defend state laws when they're challenged as unconstitutional. And so, in shameless plug, if you ever get a chance to work at an Attorney General's office, I would highly encourage you to do that. Just really cool opportunity to get great experience doing meaningful, broad impact work. The Supreme Court over the last few years has reminded us that medical autonomy is not without limits. First in Dobbs, which dealt with a state's authority to impose restrictions on abortion, and then again this past term in United States versus Scrimeti, which upheld Tennessee's authority to ban doctors from providing transgender medical treatments to minors. And some of the main questions that come up most often in litigation over the regulation of healthcare, those questions are, where is it appropriate to draw lines that restrict access to a desired medical treatment? And two, whose role is it to draw those lines? I've had the privilege of getting to litigate the Scrimeti case all the way up to the U.S. Supreme Court with a great team of litigators. I've also had an opportunity to defend Tennessee's abortion laws, and so it's really interesting seeing the debates on both sides here, but I just wanted to take a few minutes to highlight a few points about how the court in Scrimeti approached these questions. And just for a little bit of background, if you're not familiar with the Scrimeti case, Scrimeti was a constitutional challenge to Tennessee's law passed in 2023 prohibiting doctors from providing puberty blockers, cross-sex hormones, and surgeries to minors for the purpose of treating gender dysphoria or for the purpose of gender transition generally. The law came about after lawmakers learned that one of Tennessee's largest hospitals there in Nashville was performing double mastectomies, also known to some folks as top surgery, on young teen girls and giving puberty blockers and cross-sex hormones to kids even younger than that to treat gender dysphoria. The ACLU, on behalf of several kids who identify as transgender, along with their parents, and a doctor in Memphis who provides these sort of treatments to kids, or who did, they brought suit claiming that this law was unconstitutional. They said Tennessee's law violates the substantive due process. It violates substantive due process by denying them the ability to get what they framed as medically necessary care that they desired and that their doctors were willing to provide. They argued that Tennessee's law also denied parents the right to direct the care and upbringing of their children. They also argued that Tennessee's law violates equal protection by discriminating based on sex and transgender status. The Biden Department of Justice also intervened in the case to pursue the equal protection claim, and that's how we ended up getting the case name United States versus Scrimeti, in case you're wondering about that. But they were able to convince the district judge in our case to give them a preliminary injunction holding that the law violates or was likely to violate the Constitution. And so the court entered a preliminary injunction blocking enforcement of the law statewide, just like what had happened in Alabama and Arkansas the year before in very similar cases. So we filed an emergency appeal with the Sixth Circuit. I think our notice of appeal went on file within 3 hours of the preliminary injunction coming down. We titled it an emergency notice of appeal. And it must have made a difference because just a week later, the legendary Chief Judge Sutton from the Sixth Circuit granted a stay of the preliminary injunction. That was the first time a court in the United States had acted to uphold a state law prohibiting these type of transgender medical interventions. Judge Sutton ultimately overturned the preliminary injunction. ACLU and DOJ decided they were going to take a shot at the United States Supreme Court. They filed a cert petition. The court ultimately granted cert on the equal protection claim. And that's interesting because we thought the substantive due process question concerning parental rights was actually the trickier of the claims that were brought by the plaintiffs in that case. But at that time, there wasn't a circuit split on the issue, so we went up to the Supreme Court on the equal protection question. So we're talking about the regulation of healthcare, there's a couple of questions that courts look at, and Christina's already referenced this already, the different tiers of scrutiny and that sort of thing. So just taking you back to con law, just really quick. The first question, does the regulation burden a fundamental right or draw lines based on a suspect class, like race or sex? If it does, courts apply heightened constitutional scrutiny, which is a lot harder and the government typically loses. If not, then the courts apply rational basis review, which gives a lot of deference to the legislature. The law is typically upheld if there is some conceivable rational basis for believing it will advance a legitimate state interest. And so in our case, the Supreme Court rejected the argument from the other side that Tennessee's law discriminated based on sex or transgender status. And we could probably spend the rest of our panel time talking about why they did that, but I'll skip past that for now. Instead, the court said that Tennessee's law created only two classifications, one based on age. In other words, adults could get these gender transition treatments, but kids can't, and another classification based on medical purpose. You can get testosterone and estrogen and puberty blockers for a range of medical conditions. You just can't get it for the purpose of treating gender dysphoria or for gender transition. According to the court, neither of those classifications created by Tennessee's law triggered heightened scrutiny, and so rational basis review applied. Like I mentioned, the Supreme Court didn't take up the parental rights question, the substantive due process claim that was raised in the district court. But like I said, Chief Judge Sutton did address that. He had a really excellent opinion on this issue, overturning the district court's preliminary injunction. And I wanted to highlight just a couple of things relevant to our discussion here that came out of that opinion. Dobbs made clear that we identify fundamental rights protected through the substantive due process clause by looking to see if that right is deeply rooted in the nation's history and tradition. If it is, a regulation hindering that right would get strict scrutiny on constitutional review. And if not, the regulation gets a deferential rational basis review standard. Judge Sutton held that Tennessee's law restricting access to transgender medical interventions for kids doesn't implicate any fundamental right protected under the Constitution. Like I mentioned, the parents argued that they have a right to make decisions regarding the medical treatment and the care for their kids. And that's true in the general sense. Parents usually do know what's best for their kids. You can tell my mom that I said that. She'd probably appreciate it. But that's defining the right at too broad a level of generality. Parents don't have a constitutional right to reject democratically enacted laws or to veto legislative decisions about which medical interventions should be available for kids and which ones shouldn't. There's a long history and tradition in America of permitting state and federal governments to regulate healthcare for both adults and children. States also have a compelling interest in protecting the integrity and ethics of the medical profession. States also have a compelling interest in protecting the physical and psychological well-being of kids. And so as long as constitutional guarantees do not apply, Judge Sutton wrote that states may regulate or even ban medical interventions when they find that the risk outweigh the benefits. If they deem a medical treatment unsafe, states are within their authority to regulate that. As we've talked about here just a minute ago, we've seen this come up in the context of physician-assisted suicide, where the Supreme Court has allowed a state to ban that practice despite patients requesting it and physicians being willing to provide it. The court rejected the argument that personal decisions are protected through substantive due process. Same thing here. Chief Judge Sutton held that ethical principles, including the principles of autonomy, beneficence, and justice, don't offer meaningful guidance when it comes to construing the meaning of the Constitution or determining whether a law should be held constitutionally valid or invalid. And so when the Constitution is neutral about an issue, as it is in the case of transgender medical interventions for kids, legislatures have wide discretion to engage in debate over strengths and weaknesses of a policy and to make those difficult policy decisions, and those are ultimately subject to accountability through the democratic process. And so that brings us to another question. When a state regulation doesn't implicate a fundamental right and doesn't draw classifications based on a suspect class, then we look to whether or not it's reasonably conceivable that the law advances some legitimate state interest. The Supreme Court in U.S. versus Scrimetti held that Tennessee's law easily passed that test, and I just wanted to hit a couple of quick points on how it reached that conclusion in that case. First of all, as we talked about, the court noted that states have wide discretion to regulate in areas of medical and scientific uncertainty. And that's what we have when it comes to transgender medical interventions, especially for kids. The legislature in Tennessee found that the use of puberty blockers, cross-sex hormones, surgeries, they all carry significant risk. That includes irreversible infertility, sexual dysfunction, increased risk of disease and illness for major bodily functions, including cardiovascular risk. It also carries the risk of adverse psychological consequences. The legislature in Tennessee also recognized that treating gender dysphoria in kids with drugs and surgeries was a relatively new thing. This has only come up in the last 10 or 15 years. And despite that, there's been an explosion in the number of kids who are being diagnosed with gender dysphoria and who are being given drugs and surgeries to treat that condition. The state was also concerned about minors being able to fully comprehend the irreversible effects of these sorts of treatments. And the legislature also pointed to the growing number of folks who have come out and expressed regret for having received these treatments when they were kids. We call them detransitioners. There's also research showing that the majority of kids who experience gender dysphoria when they're young ultimately grow out of their dysphoria by the time they reach adulthood, assuming that they don't get these medical interventions that we're talking about. There's also a growing number of European countries over the last few years that have come out, and these are countries that pioneered medical interventions to treat adolescents with gender dysphoria. They've recently come out, Sweden, the UK, Finland, Norway, talking about the lack of evidence of effectiveness or safety, the fact that long-term consequences of these procedures are simply just unknown. And so the court held that mere disagreement with the state in its weighing of the risk and choosing a response to that risk is not sufficient to invalidate a democratically enacted law under rational basis review. The court held that states can reasonably take the side of caution when it comes to regulating areas of medical uncertainty, and it held that's what Tennessee did in this case. Some folks say, well, shouldn't we defer to the views of professional medical associations? What about the doctors who actually develop the practice guidelines in this area of medicine? Like the World Professional Association for Transgender Health, WPATH. Has anybody ever heard of WPATH? Okay. What about the American Medical Association and other professional organizations? What if they're opposed to a certain healthcare regulation because they say, well, this violates principles of medical ethics? What if they say that these prohibited treatments are within the standard of care for a condition like gender dysphoria? Shouldn't we defer to those guys about what sort of treatment that doctors should be able to provide? But in both Dobbs and Scrimetti, the answer was no. In Scrimetti, the challengers argued that every major medical and mental health organization in America was opposed to Tennessee's law restricting access to sex transition procedures on kids. And they were right. More than 24 of the largest professional medical and mental health organizations in the country submitted amicus briefs at the Supreme Court opposing Tennessee. That included the AMA, the American Medical Association, the American Academy of Pediatrics, the American Psychiatric Association, WPATH, and a lot more. And so the plaintiffs and DOJ in our case argued that the medical community widely recognizes the use of puberty blockers and cross-sex hormones as being medically necessary to treat gender dysphoria in adolescents. But that didn't make any difference to the court's analysis or to the ultimate outcome of the case. And when the case was at the Sixth Circuit, Judge Sutton wrote about this, and he wrote, just because the folks being regulated, in other words, the doctors or the drug companies, just because they say a challenge regulation is unnecessary or inconsistent with principles of medical ethics, that doesn't make it unconstitutional. And while the Supreme Court majority didn't address this directly, Justice Thomas hit it pretty eloquently in his concurrence. He wrote that medical experts don't have license to override the wisdom or logic of legislative choices. And regardless, in this case, there was not a true consensus about how best to treat kids experiencing gender dysphoria. And we've seen that through the evolving debates with the national health authorities in Europe. We've seen that with the fact that more than 24 states across America have enacted laws similar to Tennessee's. And Justice Thomas wrote that questions of medical ethics, like whether kids can truly give informed consent, are questions that states have to decide for themselves. It's also important to note that the positions of the medical consensus or professional medical associations tend to shift or evolve over time. Just take WPATH. WPATH in the late 1970s came out with the first standards of care for using medical interventions to treat gender dysphoria. But according to their standards in the 70s, those were recommended only for adults. Fast forward 20 years, and then they shifted their position to allowing hormones for those 16 and up. Fast forward another 15 or so years to 2012, WPATH shifted again, and they removed any age requirements for hormones. And then in 2022, the year before Tennessee's law was passed, WPATH shifted their position again and said that it's appropriate to allow gender transition surgeries regardless of age. And thanks to our good friends at the Alabama Attorney General's office, we now know that the most recent shifts by WPATH and similar organizations who had endorsed their standards were not because of scientific advances, but because of political pressure from the federal government under the Biden administration and the influence of what they called social justice lawyers. You should check out the emails that they got from WPATH. It's really remarkable. Just last month, the American Society of Plastic Surgeons came out and said that because of the lack of evidence of safety and efficacy, that they were recommending that surgeons refrain from performing any surgeries related to gender dysphoria until a patient's turned 19 years old. So again, that's a shift from what the latest standards from WPATH are. American Medical Association came out the very next day and said the same thing, which was also different than its prior endorsement of the WPATH standards of care. So again, it's obvious that ethical standards of care can shift, and so it'd be problematic, as Judge Sutton wrote, to assign weight to that when it comes to determining what the Constitution means. Even early last century, the medical consensus when it came to mental health was that we could treat severe psychiatric illness with lobotomies. Again, that's no longer the case. You saw the same type of argument about deference to the medical consensus a few years ago in the Dobbs decision. In that case, challengers to Mississippi's abortion law argued that the overwhelming medical consensus in numerous major medical organizations rejected Mississippi's argument that its abortion law, banning abortion after 15 weeks, was justified by its interest in minimizing fetal pain. But, I'll wrap up. In that case, the Dobbs court held that the views of the medical consensus didn't shed light on the meaning of the Constitution. Same thing happened in the Scarametti case. Top takeaway from the court's analysis in Scarametti is that where there's not a constitutional guarantee and there's ongoing debates about the safety and efficacy of innovative medical treatments, these hard policy questions about the appropriate bounds for medical regulation are left to the people, their elected representatives in the democratic process. Thanks.
We can have a brief discussion. We're going to do some lightning round questions because we have not preserved much time for conversation if we're going to also have audience questions. And I know somebody out there is really excited about the prize that I have for you. So be getting your questions together. These people here, they're not excited about the prize, but the rest of you are. Dr. Arkes, I wanted to just nail down one bit of the presentation that you had. You talked about being in a current moral crisis, and I want to make sure that we understand the moral crisis. What I understood you to be saying is that conservatives have overcorrected. So we went through a period of time that liberals were enshrining progressive morality in positive law, and the conservative response was to remove all morality or moral basis for positive law. So from a jurisprudential standpoint, how should conservatives do it? Is positive law just something that should be a moral debate?
Of course. Well, of course. Does this work?
I don't know.
Is it working?
There you go.
Okay. No, it was long understood that, you see the sign saying 65 MPH, 35 MPH. It used to be understood that before you get a positive law like that, there must be some underlying law principle that tells you why we'd be justified in restraining the freedom of the people to drive at speeds that put innocent life at hazard. So the natural law has always made a place for the positive law. The real problem here comes with, say, Amy Barrett just apologizing last week for using substantive due process in the case on genders, protecting parents in California, get information about the kids being groomed for transgenderism. She thinks that substantive due process, that these rights are somehow less important as rights, and that as soon as you leave the text of the Constitution, she says, we move into a zone of privacy. It's like Bob Bork used to say, as soon as I leave the text of the Constitution, I'm looking inside myself. Well, we knew that when I say with Dick Helmholtz, the natural law says you should have a summons to know that you're being targeted for process. I'm not making it up. It's not a private thing. We can look for serious principles of law. We're looking. See, some of my friends, including my late from Scalia, would simply back away from the notion that we can reason about these things in moral terms. That his position was that we are too divided on that question. The fact that we disagree on those things does not mean that there are no truths for us to discern. Neil Gorsuch reveals that, guess what? Originalists can disagree on these matters, and yet originalism has things to discern. The critical point, one thing, forgive me, John, that came up here, is that this should have been no problem on the substantive process of parental rights. As fathers recognize, every liberty carried a form of a license. Parents will have a liberty to make the decisions for their children, but of course it implies there's a possibility to get it wrong. They may order up things that are injurious to their children. They may sell their children, rent their children for pornography. Recognize that. So it's no problem to recognize, yes, there's these serious parental rights, and that we have also the grounds on which to restrict those rights. It comes along with the whole scheme. So my friends have moved on too quickly for the assumption that if it's not in the text, we're making it up. There are no real moral principles to discern there, apart from what's in the text. That's been a serious mistake.
Christina, I wanted to ask you, one of the arguments that you made here, and that I know is a big argument on the right to try, is the opposition to the paternalistic government in this space. But one of the major arguments against the transgender surgeries and interventions for minors is that parents in that space can make irreversible and devastating decisions on their children's behalf. So what are your thoughts on protections or limitations on what parents can decide for their children within the right to try space?
Yeah, I think, as I said, I think what it means to be free means the right to make dangerous or risky or irreversible decisions. But of course, children are different because children lack the capacity to be able to make those decisions for themselves and to be able to consent. I actually think that right to try is even easier than the Scrimetti case because, we're talking about saving somebody's life, even if it's a long shot. And although, courts have given parents wide range to make healthcare decisions for their children, and one of the areas where the courts have said that the government should be entitled to step in, because again, the government also can step in, right, in loco parentis, but is when a child's life is on the line, and so parents don't have the right to refuse life-saving treatment for a child. And so I think you could argue that in a situation like right to try, even if it's a long shot, even if there could be some side effects, it's better to defer to the parents rather than to defer to the government in making those decisions. but it's not an easy line to draw. It absolutely isn't, and I do think there's a legitimate role for a parent or even for government to play when you're talking about people who lack the capacity to consent.
Thank you. And Stephen, and after this, I'll be asking for an audience question. There's an undeniable tension. You started to get, and then I cut you off, so sorry about that, briefly into the abortion context, which I know is your current litigation space. And one of the interesting things that I think is going on in the Tennessee litigation has to do with the very narrow medical emergency exception in the law in Tennessee. And your offices and the courts, they're grappling with what qualifies as a sufficient emergency. So from the litigation perspective that you approach this, how are you balancing the legislature's desire, the sort of policy desire for unambiguous prohibition and clarity with the undeniable clinical reality that physicians need workable guidance? They need to know when the exception applies. How is that working itself out, or is it working itself out in the litigation?
Well, it depends on who you ask. You either ask the state and they think it's clear enough, or you ask the advocates for broader access to abortion and they say it's not. But that's a good question. We see these debates playing out in the states across the country after the Dobbs case, which held there's no constitutional right to abortion. And a lot of the cases that are being filed in state court under state constitutions, which don't always map on one-to-one with the federal constitution. And so, like Judge Perkins mentioned, a big focus in the state court challenges to abortion statutes lately has been on whether the statutory language regulating abortion is unconstitutionally vague. In other words, does it put doctors on notice of what is permitted and what's prohibited? And so that's a big feature of the case that we're working on right now. We've also seen plaintiffs raise claims that state abortion laws hinder their ability to terminate pregnancy when it's necessary to save their life. And so, we talked about fundamental rights and the right to life arguably being a fundamental right. And so the crux there is that, well, in Tennessee's case, our statute has an explicit exception for terminating the pregnancy in order to prevent the woman's death, is the statutory language. I'm not sure how much clearer you can get in the statute to say you can perform an abortion to prevent the woman's death. And then our statute also has specific examples of the types of serious medical emergencies that may come up and threaten the mother's life for which abortion is permitted, just to provide that extra guidance to doctors and give them peace of mind. And what we've heard from a lot of doctors across Tennessee is that, our practice hasn't changed. We already knew what reasonable medical judgment allowed when it comes to terminating pregnancy. We know what serious medical conditions are and when the life is threatened. And so a lot of folks have said this hasn't changed. We have a group of doctors who have sued to challenge the law, and they have a different perspective. But some of the harder questions that folks raise that may have more debate is, well, outside of the context of saving the woman's life, where do you draw the line beyond that? So, for instance, if a woman finds out that her baby has been diagnosed with a life-limiting fetal anomaly, or she finds out that her baby's been diagnosed with Down syndrome, should she be allowed to terminate the pregnancy then? What if the woman has a psychiatric illness that's well managed using medication that's ultimately harmful to the baby's development, and she's scared that if she gets off that medicine or changes to a different treatment regimen, that her psychiatric illness will go off the rails? Is she allowed to terminate the pregnancy to save what she thinks is preserving her own mental health condition? There's all these sorts of questions. Say a condition doesn't threaten the woman's life necessarily, but what if it threatens her future fertility? Should she be able to get an abortion then? And so
what I hear you to be saying is, stay tuned. The Tennessee AG's office is on it, and we'll be hearing more about how these lines are drawn after this litigation proceeds a little bit further down the path, at least some of them.
Well, and going back to the point you made earlier is that, when there's no constitutional guarantee at issue, then that decision is ultimately left to the democratic process and surviving rational basis review. Can you articulate a rational basis that advances a legitimate state interest?
1 minute and a half.
1 minute. Let's see if he can do it.
I'll do this hebraically by omitting the vowels. The judgment was made by Jeff Sutton. We recognize the judgment of a democratically elected legislature. And the problem that you could have said the same thing for Buck versus Bell on compulsory euthanasia. And the question we're putting, which elicited the invitation for Jerry Bradley and me to come meet with Jonathan and his crew, was the legislature in Colorado reaches a different decision. They think there's something good about gender-affirming care. And so the question is, why would we settle for a decision that could be simply a concurring opinion in Buck versus Bell? Why couldn't we appeal to the root of the problem, which is that the whole thing is predicated on falsehoods? There are prodigious cosmetic surgeries which engender long-term, enduring ills. Penile transplants, double mastectomies. And the point is, these surgeries can never convert males into females and females into males. Why can't we simply say the whole thing is predicated on a falsehood? It's as wrong as Tennessee as it's going to be in Colorado. And that's what brought the invitation from Jonathan to come down for conversation.
All right. We have some questions. Whoa, nice. This is a good way to get questions. Okay. Here in Scalia Law, you in the middle, that was the first hand up I saw.
Wait, who? Yep.
They're trying.
I'm going to throw it. We're going to get ready.
That was interesting stuff.
Well done, both of you. That was some good, lawyers not known for our athleticism, but good job.
First, Corbin Witt, Scalia Law, 3L. I have a question, not just to get a prize, but actually for Mrs. Sandefur. So in two English cases that I'm sure you're very familiar with, those of Charlie Gard and Alfie Evans, one of the many bases for denying the parents the right to try for their children's lives was a concern that the kids had a human dignity interest in not being experimented on, and that there was kind of the subtext that they were worried about large pharmaceutical companies exploiting children as test subjects. I never found that all that compelling, but I'm interested to hear what your rejoinder to that specific issue is.
Sure. Well, again, when we're talking about children, it's always going to be tricky because they lack the capacity to consent for themselves. So then the question just becomes, who's the right person to make the decision? And again, there's lots of exceptions to this, but generally speaking, I think it makes sense to default to the parents because, and to get to the other part of your question about pharmaceutical companies having special interests, there is no actor involved in the decision-making process that doesn't have some sort of bias, right? I think that's sort of, that type of question or drawing a line saying, well, we've got to protect children from the evil pharmaceutical companies, well, that assumes that the protector also doesn't have his own bias. Make no mistake, government officials have biases. Doesn't mean that they're bad people, doesn't mean that they're evil people, certainly doesn't mean that they want children to die awaiting life-saving treatments, but as we know, the FDA operates under the precautionary principle, right? They say, well, better not take the risk because look at the, what can result. If we approve a treatment for a child and it ends up hurting that child, well, then we've harmed that child. What we're not looking at, though, when we put that principle forth, is that what about all of the kids that died, suffered and died, awaiting a potential treatment that could have saved their lives? Those are unknown. Or also, what about removing the dignity from an individual to make that decision for themselves? And again, a little bit different with children. So, I think every single actor here has a bias, and that's why the right principle is to defer to the individual, because the individual is biased toward themselves and toward having to make decisions with which they will have to live and suffer the consequences. And so that's why, to me, the default always goes to the individual. When it can't go to the individual, absent a good reason, and sometimes there are good reasons, and those are oftentimes spelled out in the law, it should go to the parents.
All right, maybe one more if it's a short one. All right, just behind our questioner, you were next hand. Great.
I'll spare you the toss.
Look at that microphone.
Hi, Lauren Curry from South Texas College of Law, Houston. And I did have a question on just kind of clarifying when you mean the right to try, drug treatments that are like either different drug things. Do you include like surgical operations that are innovative and maybe risky because maybe there's not a lot of doctors who can operate in that manner? And I was just curious if that did include the surgical operations besides just medicine.
Yeah, so in terms of what the federal law includes, it is, in my opinion, unfortunately, just limited to drugs, not biologics. Although, of course, in my opinion, on the right to try broadly and what the fundamental right to try covers, yes, I would say that extends to drugs, biologics, surgeries, all of the above.
That was very quick. We could do one more. Could we be succinct? Up in the back there. I'm giving Esther her steps today. You're welcome.
I didn't realize this was a microphone. I was just wondering if there's kind of a risk of going too far with like stigma towards a certain group, and that you would just get like a rehashing of like the Bowers v. Hardwick, Romer v. Evans line of cases where the court would like invoke animus. So is there like a better strategy to kind of like incrementally sort of protect like minors who are at risk of these types of procedures, or is it better to go kind of like all in immediately and perhaps
I'm not following your question, and I'm also not sure who you're directing it at.
Oh, it's a bit difficult to see, but the gentleman in the red tie.
All right, Mr. Griffin, and you're asking, sorry.
Yeah, just, is it kind of risky to possibly have some sort of fact pattern where someone has suffered like a large amount of stigma or something like that, and then they do have like a sympathetic court, and that creates like bad precedent, sort of like bad facts make bad law?
Are you asking if the Scrimetti decision is going to cause this problem?
I'm asking if like maybe a certain state would have like too much all at once, and that sort of just creates a situation where there's like too much pushback at once.
I can answer really fast.
Go with it.
All right, I'll try to answer really fast.
All right.
Because there's a few different things at play there. You know, one thing when Tennessee was sued, it was in the middle of a time when there were several laws coming down related to transgender issues, including bathrooms, sports, medicine. And so one of the arguments from the plaintiffs was like, Tennessee just hates transgender people because Tennessee believes in biological reality, right? So,
That's right.
yeah, so, you know, one thing the courts would look at is, even in rational basis review, you know, is there evidence of animus toward a group? Is there prejudicial animus toward a group? That argument wasn't even made in the Scrimetti case, but it's something that, you know, theoretically could. The other angle to this is, well, in the equal protection context, for instance, there was an argument that the law discriminated based on transgender status, and they argued that transgender status should be elevated to a suspect classification, which has never been done. And so one of the things that they would look at in determining whether or not a classification should be entitled to heightened scrutiny is multiple factors, but one of those is a history of animus. Justice Barrett got into this in her concurrence. Ultimately, the court didn't address that question in Scrimetti. It might in the BPJ case coming up about athletics. I don't know, but they didn't in Scrimetti. The justices that did write about it indicated that it would not be a suspect class, but that's where that might come up.
Great. Thank you. Thank you, everyone, for sticking it out. We have a...
Nice job.
Do we have any housekeeping?